What about reviving your old green card with the old employer? This is Sam Shihab, and with me,
Brian Burke,
from the law firm of Sam Shihab and Associates. We're going to talk about a very important topic, and a popular one is looking back, and maybe the old green card may be something that you can revive and take advantage of when we come back. So every Monday at 6 o'clock Eastern Time, we get together, Brian and I, and talk about a topic regarding employment immigration law that we think important to the immigrant community, to our clients, and to anybody who is in the employment immigration long line. And
enthusiasts, Sam, for the enthusiasts. I think this is a good topic for the enthusiasts.
We spend about half an hour talking about the substantive issue and if there's any current event. And then the second half an hour, we talk about any questions you have. You can bring any question and we will do our best to answer it for you. So today is a topic that's, I think, important, is reviving the old green card. You worked for this employer 10 years ago for a year or two or less. Mm-hmm. They filed the labor certification, was approved. They filed an I-140.
Filed an I-140, yeah.
Approved, and then you moved on.
Yeah.
And they may have withdrawn the I-140. They may not have withdrawn the I-140. And then 7, 8, 9, 10 years later, you're running out of H-1B time. Something happened, and say, "Wow, what happened to that old green card with that very first employer?
Yeah.
Can I take advantage of that? That priority date is really nice, and I don't have a good."
It's very common right now because people say, "Oh, that prior employer did a green card for me in the EB2 category, and I'm only in EB3 with my current employer, and as the EB2 dates are ahead, that looks attractive."
Or I have an EB2, and I just want to have a second one.
Yeah.
To be on the safe side.
Yeah.
And so I want to pursue both of them. So we're going to talk about the dynamics of that, what can be done, what cannot be done. It's, believe it or not, a slightly complex and technical issue, and we broke it down to subcategories.
Yeah.
And the first subcategory is...
We're going to talk about the simple scenario first, where your priority date's not current. You haven't had the opportunity to file I-45, but you have a prior employer that filed an I-140 for you. And the question is, can you go back after they've really withdrawn that I-140 for you? So I-140 is withdrawn, isn't it dead, Sam?
I-140 withdrawn, it's not dead, and that's really an important thing to understand.
Yeah. So fundamentally, as long as your labor certification was filed with an I-140, and if your employer withdraws the I-140 later, USCIS doesn't care if the labor certification is old or quote-unquote expired per its face. They allow your employer to come back and file a new I-140 based upon your labor certification, even if they've withdrawn the I-140 in the past, basically undoing their withdrawal by doing a new filing, essentially.
So I'm going to drill on this a little bit so everybody understands. When the labor certification is filed, you have a window of 180 days by law to file the I-140.
Yeah, when the labor certification comes in, on the bottom of it, it says, here's the validity period, and you have to submit it to USCIS with an I-140 during that window. Yeah.
Within 180 days.
Yeah.
And if that does not happen, that labor certification is dead.
Yes.
There's nothing you can do about it. It's gone.
Yes.
Now, if the I-140 is filed within the 180 days, and let's assume you've left this employer, and let's assume that I-140 is withdrawn, or not withdrawn, let's assume that it's withdrawn, you can go back 20 years later.
File that I-140.
And revive that old labor certification and revive that priority date.
Yeah, and I guess it's worth saying what are the issues related to that when going back to an employer who you have a withdrawn I-140 for and saying, hey, can we revive this thing? Well, one, there's a potential for RFEs, and the most common one you're going to get on that one is about your employer's ability to pay the offered wage set forth on your I-140.
Right.
Is that a potential issue? Yeah, but that's a financial analysis that your employer can make before even filing the case and figure out if there's going to be an issue. Basically, that's addressed by making sure the company has strong financials that show they have the ability to pay you that wage, despite the fact that you weren't employed with the company for a while.
Right.
The other challenge you get is they won't allow you to file that I-140 in premium processing, that revival I-140 where you reactivate your old labor certification. Why? Because there's this policy within USCIS where they say, in order to revive an old labor certification, we actually have to go back and get it. And that historically, that would mean going back into their hard files, grabbing the original official blue labor certification document that was issued by the Department of Labor, and adding that to the new file, and that takes some time. And because of that, they won't accept an I-140, a revival I-140 with premium processing, generally speaking. However, it should be noted that sooner or later, they are going to find that labor certification, and once they have the labor certification in their hands, they're going to allow you to upgrade that case to premium processing. So it's not.
So shortly thereafter, you can upgrade. I mean, you can send the let's say the premium processing upgrade. Let's say 2 months later, and then they can come back and say, we don't have it yet. They send you the check back. You can send it 2 months after that. Usually they ask you to wait 60 days or so to submit it again.
Yeah.
And then you can submit it again, and then if they have it, they will process it in premium processing, and boom, you have an I-140 approved.
Yeah.
Right?
Great.
And now we're talking on the subcategory of the priority date is not current.
Yeah.
So you're really not ready to file the adjustment yet.
Yeah, and we like talking about that first one because it's a simple scenario. It's, one issue. Can you go back to the employer and bring back the labor certification and your I-140 with them? Yes, you can. New filing. It's something we've done a fair amount. Good. Now, it gets more complicated, Sam, when we talk about, your priority date's current and perhaps you've filed an adjustment of status or you're about ready to file.
Before we go there.
Sure.
On the non-current front.
Yeah.
Maybe, is there a requirement that you have to join your employer?
When they're filing an I-140 for you?
Yeah.
No.
If it's not current, there's no requirement. You can continue working for this current employer, who's also could be doing your green card. You could be talking to a prior employer, say, hey, I'm willing to pursue a bona fide job offer with you, revive my 15-year-old green card labor certification for me, file the I-140, and if that eventually, of course, 15-year-old prior date will be current, so we're going to say 8-year-old maybe or 7-year-old. Perhaps, and I'll join you later whenever the prior date becomes current, or some kind of a deal that you can have with them, no later than obviously the green card approval.
Yeah. So the general rule is that you don't have to join the I-140 employer until USCIS gives you a green card. That's the absolute last minute.
Now, the second subcategory is the priority date is current, and again, we're talking about reviving your old employer, old green card application. Now, if the priority date is current, what changes?
Well, so there's all sorts of subcategories related to that. If your priority date is current, you can do more stuff. You're with employer B and you want to go back to employer A. Suddenly you have some options. If you have never filed adjustment of status before, you can file I-45 and I-140 at the same time with the old employer. And this is a realistic scenario. Concurrently. It happens that, you leave, you get tired of employer A, you're done with them, you just want to try something different. You think my priority date's never going to become current, right? And then you join somebody else, and then you're with employer B, and then your priority date becomes current, and employer A comes knocking and says, hey, would you still want to work with us on a permanent basis? And that's a scenario where you can file I-140, I-45 at the same time to revive that old I-140 with that prior employer.
Revive the entire green card process.
Yeah, revive the entire green card process, yes.
And you can continue now, as far as where you're working, there is no harm of continuing to work for the current employer.
Yeah.
And you don't have a legal obligation to inform them of anything yet.
Yeah.
Moral obligation is different, but we're talking law here. And you can continue working for them, and you can be clear to the old employers, hey, if the green card is approved, I'll join you. Or you can join them earlier. It's up to whatever negotiation you have with the employer and however you feel your career goals and direction. And maybe the prior employer now has great technologies and great benefits, or maybe better location, which we're going to talk about location later.
Yes.
But all these options are on the table for you to negotiate, and probably a good idea to have your attorney involved to kind of guide you, because there's little bit of a technicality going on.
Bottom line, though, is you're not required to join employer A, the first one who you're reviving through, going back to, until a green card is in your hand, and that's clear government policy on that front. However, I got to mention, Sam, sometimes USCIS likes to interview people, and I know back in fall of last year, I was seeing a lot of interviews for people who had filed green cards through that company A while working through company B. So one thing I got to say is, that could potentially be an interview trigger for USCIS. Not everybody who has been in that scenario has got an interview, but I've went to a lot of interviews.
But it's not a big deal. It's easily handled.
Yeah.
It's not like, oh my God, I'm in trouble now because I did that. It's perfectly legal, and your attorney will advise you during the interview to advise the government that I will accept the first green card approved.
Yeah.
I have no problem with it.
Yeah.
Okay, great. So this is exciting stuff. Now, is this a good time to throw in supplement J, or is this complicate things too much?
There's so there's a question. Can I file? And this is the one that comes up a lot. It's can I? Company A has my. I'm working with Company B. Company A filed my green card. Can I file my green card through Company A and then wait 180 days and then submit a supplement J through 180 days portability and submit a supplement J back to Company B? Company B's happy they never had to file a green card for me, and Company A, well, bye-bye.
Okay, so the scenario, as I understand it, is you go back to Company A and say, hey, get my I-140 reinitiated, and if it's not withdrawn, there's no issues there. Priority date is current. You tell the prior employer that, hey, support me filing the I-485.
Sure, yeah, file I-140.
And then I have every intention to move 180 days back to the first employer.
To the one,
The current employer.
Yeah.
Company, employer B.
Yeah.
Well, obviously there's a problem with that. Let's be very blunt on this. And there's an intent problem. When you accept that Company A filed an adjustment of status for you, you must have the unequivocal intent to join that employer, and you will sign that declaration under oath in Supplement J with the employer A that you, at that moment, intend to join them at the green card approval. You cannot have a different intent at that time. Now, the intent can change in the future, however. Brian, help us with that.
It is possible. I can imagine scenarios where you have every intent to go back to Company A and your first company, the company you're reviving your I-140 and filing adjustment status through, and something changes. If you get to the 180-day mark with Company A and Company A says, hey, we don't have an offer of permanent employment for you anymore, I'd say in that scenario, you have a great argument to supplement J yourself back to Company B.
Or Company B now have an amazing contract in which will seriously propel your career. And they said, hey, we got this contract with Mercedes. We got this contract with IBM.
It's a changed circumstance. Something that, that would indicate a logical reason to change your intent. And there has to be an actual, because intent, Sam, we're talking about explanations for your intent, but the bottom line is intent is in your heart, which the government doesn't have the means to monitor quite yet. But
intent is more than in the heart, Brian.
I agree.
Intent is in your emails.
Yeah.
Everything you think about is in your emails. Even your dreams, unfortunately, may be in the emails.
Well, until the government has an intent detector, you should have good documentation that lines up with your intent. Yes. Explains why your intent changed.
But if the intent change after 180 days, you can certainly supplement J to anybody.
Yeah.
Without joining that employer.
Yeah.
Employer A.
Yeah.
No problem.
Yeah, I think, the situation changes a little bit. Let's say you already filed your adjustment. You already filed your adjustment of status with, say, this new company. Let's change the facts of Sam. So this Company B, you joined them and they filed a green card I-140 for you in the EB3 category, right? In October 2020, you filed with that because, EB3 was way ahead. You filed adjustment status there. But now you're thinking about your older company where they filed for EB2 for you, and EB2's way ahead. Yeah, Company A. EB2's way ahead, and you're thinking, I would love to be in the EB2 category, and the company B is not offering me an EB2 role. They did me a straight EB3 perm I-140, and they can't. There's no means it can be an EB2 I-140. Going back to that company, the prior company, it's going to require. It can be well. We're going to transition a little bit to interfiling, transfer underlying basis as well, but. Is it possible, Sam, to have a pending adjustment of status based upon the EB3 from company B that's stuck in EB3, right? And a pending adjustment of status from company A based upon, you file a second adjustment of status with company A, go back, revive that I-140, file adjustment of status there, so you get the best of both categories.
Absolutely. And you can have both at the same time.
Yeah.
You can have 2 EB3s, 2 EB2s, 2 EB2s and 1 EB3 in 3 different companies.
And
you can have
for
infinite.
me, it's really easy to justify. It's I would really like my U.S. green card, and you're allowed to want a green card. You've been waiting long enough for one, and if the government would ever ask, it's I am willing to. I guess I'm in pretty high demand. I definitely want my green card. I'm happy to join either one of these companies. Whoever's able to get me that green card first, I know the rules. I'm going to be joining them, and that'll be the end of it. I'll have a green card. I'll be happy.
Yes. Yes. That's awesome.
Yeah.
All right. So now, again, we're going to throw in interfiling. Now, right?
Yeah.
Now, let's kind of reset the foundation here so people don't lose us. We're talking about reviving your green card. We're talking about reviving the old green card with the old employer. And now we're going to throw in an interfiling layer on it and how that interplay with that concept.
So it implies if it's interfiling, it implies you have a green card filed through some other employer, the company B, a newer employer, but company A, well, you'd like to get back there, and is interfiling an option? The answer is going to be yes, but if the I-140 has been withdrawn, you need to file a new I-140 to revive that so you can interfile to it. You had all the problems we discussed before, potential for RFEs and lack of premium processing, at least initially.
But every case has a potential for RFEs.
Yeah, this is very, very, very true. Yeah. I would say that an I-140 downgrade or an upgrade or whatever
all of them have
is subject to incomplete re-adjudication.
But the first step is you need to revive that I-140 if it has been withdrawn.
Yeah.
And that is done by filing a new I-140 on that 8, 9, 10, 12-year-old labor certification, which had a prior I-140 which was withdrawn, and now you're refiling this I-140 now. You're reviving this labor certification. Now the next thing you're going to do is?
Or you're going to get out a Supplement J and have a nice attorney write an interfiling letter to USCIS and say, I'm leaving company B, I'm going back to company...
I'm moving my adjustment.
Yeah, moving my adjustment. I'm moving my permanent employment. Now, Sam, this begs the question, can you keep working for company B while you submit the interfiling request transferring your adjustment to company A?
Yeah, it's going to be tough questions, Brian.
Well, I got control of the conversation.
Yeah, you do.
And,
but let me answer, see if I'm right.
Okay.
Yes.
Yes. Well, we go back to the requirements. Is you only have to be in that final green card position when USCIS puts that green card in your hand.
So you can, and you don't have to wait until the I-140 is approved. Once the I-140 is filed, you can interfile the week after.
That's a great point. You don't have to have an approved I-140 to do interfiling. The policy is very clear that you can interfile to an in-process I-140.
Would you recommend that, however?
I know a guy who just a couple minutes ago said, Brian, you can get an RFE in any case, and that's what I worry about. If you transfer your I-485 to the new in-process I-140 and that I-140 gets denied, once that I-140 is denied, it's too late to transfer underlying basis.
True, but it's not a surprise. It's not something that we cannot figure out in advance. So if you're doing this...
RFEs usually come before denial. This is true, yeah.
Well, not only that, but you need to talk to the company. The issues are the issues. And we'll talk about them, the job description, the financial ability, and we can go through 1, 2, 3, 4 on a checklist and deeply analyze the potential for problems in advance. And we can say, we got companies, we see their tax returns, and I say, I absolutely have no problem interfiling to this company.
Yeah.
And other company will say, I'm not so sure, you got to be careful, right?
You have to do a detailed financial analysis sometimes.
So we, as attorneys, your attorney, should have a handle or able to have a handle on whether or not this is advisable to interfile into a pending I-140.
Yeah, speaking of your attorney talking to an attorney, there's all sorts of fun little concerns that come up when you talk about interfiling, any interfiling scenario, but we are obliged to bring them up here because we're attorneys and that's what we do. We get into the nitty-gritty details.
Yes.
One, Sam, Child Status Protection Act.
Yes, fantastic. So the whole idea of reviving the old green card brings with it the question of whether or not it will impact my child who either is over 21 or soon will be over 21. So if you don't have children around that age, you don't have to worry about it. But if you do, you must address that.
Yeah. So long story short about the CSPA is that the benefit you get from it is tied to your I-140 processing time. Your child's ability to get a green card could potentially be tied to how long your particular I-140 was in process. And you are talking about changing the I-140 that is relevant for that purposes, and that means you should probably be doing a detailed analysis on that if you have a child that's potentially impacted by that.
But wouldn't you agree that the Child Status Protection Act is also potentially in play for careful consideration without interfiling? Let's say you're doing a new adjustment.
Sure.
And reviving the old, and then you could control that by, you could have a situation where the child has aged out.
Yeah, on one I-1 versus on one I-140, but hasn't aged out on another one, and you would desperately want USCIS to approve you in the right category, such that your child gets that green card rather than not getting a green card.
I can think of a potential scenario in which your current adjustment has aged your child out because you filed the I-140 in premium processing. Mm-hmm. But if you go back to your old employers,
where you took it, where they said, you're not going to be caring for years, it'll take 7 months to approve.
And assuming the I-140 was not withdrawn, and the old I-140 took 1.5 years to approve.
Some appeals, a couple RFEs, sure.
And this child on that reviving old green card could have unaged out, get back into play and getting their green card.
That's always a funny thing about the CSPA, Sam. In theory, it's possible there's a world where 5 RFEs and a denial and followed by some appeals in a court case are good for your whole
child.
family, for the child.
Yeah. Yes, which is crazy, right?
Not good for your sanity, the status of the hair on top of your head, or your sanity,
and your bank account.
Or your bank account, but yeah.
Yeah, but potentially. So the Child Status Protection Act is a big deal as we deal with all these things because it does affect.
Yeah.
And that's a huge issue.
So Supplement J, interfiling, you do an interfiling request, also restarts the 180-day clock for portability. So that's the USCIS policy on it. That's what they say their policy is. So if you are interfiling, and it doesn't matter if it's back if it's a revived I-140, you still have to take it into account that you won't be able to. That will reset the time. Mm-hmm. So let me see here, and you can't really undo an interfiling request.
Right.
Yeah.
So interfiling is a one-way street. So once you go into the interfiling route, that adjustment at least, you cannot move it back. Can you interfile to a third one?
They do mention in the policy that you might be able to do additional interfilings amongst the employment-based categories.
Yeah. But you can file a new I-485.
This is true.
And not having to worry about that.
Yeah.
All right. So again, we're talking about reviving an old employer green card application for you because all of a sudden it's attractive, it has a fantastic priority date, and there's a job opportunity that you can join them. And we're gonna move on to talk about.
I'd say we go more into the nitty gritty. We talked about, is it possible? Yes, but the devil's in the details, and we were talking all this afternoon about, okay, that old I-140 is still there. But is it good? Is it really feasible for me to go back to that I-140, that offer from 10 years ago?
Yes.
And
so what are the challenges that we normally see, or that the person would have to kind of cover? Start with the first one.
Well, so it's a change in your work. 10 years on, probably, assuming you're from India who has a backlog that long, the work that your prior company wants to bring you back to might not be reflective of what's in your I-140 and labor certification.
So job description.
Yeah.
So job description could be outdated.
Yeah.
Now, can that be remedied?
Well,
It depends.
depends on what is outdated.
Yes. So if we are looking at skills, so if there is an outdated technology, but you are using other technologies that replace this outdated technology, that's fine.
Yeah. Yeah.
What about promotion?
A major change in your work, if you're not gonna, no, that could be a problem. I can think of somebody who I know.
Well, 10 years, everybody moves up, and nobody does the same thing that they've been doing 10 years ago, Brian.
Yeah, and
So that's a problem for every labor certification out there.
well, there's the same thing, and there's with Sam, we're talking about, you need a new I-140 if there's a major change from the prior one.
So if you are within the SOC code, so you were maybe a level 2 or level 3, you became level 4, let's say mechanical engineer.
Sure.
And you are still a mechanical engineer,
Sure.
but you are in a lead level, mechanical engineer.
Yeah.
What do you think?
Well, Sam, I'll ask you the question. Again, the devil's in the details. Leading on substantive issues, just the guy we all look to, or are you supervising people?
Well, let's take it. So you have now brought in supervisory, which is an excellent point.
Yeah.
So also there is a higher level of responsibility. So you were maybe doing independent work. Mm-hmm. Now you have discretion to conduct meetings, talk to management, but it is just the same thing. We did not add a supervisory box in there. Keeping that out for a second. So it's a vertical movement, more of the same on the higher level. Is that a problem? Using updated technology.
I would say you're
We're good.
Yeah, you're
in good shape.
Yeah.
Now, I'm going to pile on top of it supervisory.
I'd say there's a good argument the government can make that says that's a material change.
The red light is on a little bit.
Yeah.
Okay,
Yeah.
the red light is on, so we have to be careful.
Yeah.
Okay. All right, so what other changes that would be a concern?
Oh, the best one I think is location. Location. Every time you file an I-140 and a labor certification, a critical component, because it determines what the wages are and where the recruitment's done for the labor certification purposes, is where's this person going to work?
Intended job employment, yeah.
Yeah. If your labor certification and I-140 reflect a single work site that your employer no longer has work available for you at, that's a problem.
But some labor certifications are drafted on a national scope.
Yes, some labor certifications, they call them roving employee cases, are where they're drafted to reflect that, hey, this employee could work for any of our clients around the country. Well, obviously, a change in work site is contemplated for that labor certification.
So, so the details of the labor certification is critical to understanding whether or not joining the employer. If it is narrowly drafted to one location, and you're somewhere else, you got a problem. But if it's drafted broadly, then you don't have a problem. Job description gives you some flexibility.
Well, I gotta say one thing about that location. If you're not in that location right now, ultimately it can be a condition of your employment to go back to that location if your employer has work available there, and that's something where you can work around that. But
yes.
yeah.
Yes. Now we've talked about this on and off this afternoon. Is the scenario of, hey, we have a position in our company as a lead with supervisory, but the labor certification doesn't have that. We're willing to offer you either position. We're willing to offer you the non-supervisory. We have both of them. We will offer you the non-supervisory position. We'll file the I-140. Once that's approved and once the priority date becomes current, we're willing to extend a second offer of that lead position and file a supplement J within the same company. So the supplement J, not a changed employment supplement J, but a supplement J within the same company. Is that remedy plausible?
Yes. I mean, USCIS policy states that, contemplates the idea of a supplement J within the same company. However, the threshold is you have to be able to file that I-45 and supplement J in good faith when you initially submit the case. So if you guys, it can't just be a sneaky scenario. You guys, you have to have a legitimate intent to take that I-140 perm job and honestly take that other bit off the table. If it's about changed circumstances. If circumstances change down the road, if somebody says we may have something for you in the future, yeah, something more advanced for you in the future, great.
And also, but potentially also, let's assume that the technology have changed, the duties are the same. By the way, the title doesn't have to be the same. It can change a little bit as long as within the same SOC code, no problem. But let's assume that it's kind of got changed a little bit here and there. We really believe it's the same job. It's a great way to clean it up by doing a supplement J later to clean this up.
Yeah.
100% say, hey,
if there's any doubt, yeah, because certain, people, talk about what I'm doing right now and what my labor certification says, and you can look at them and say, oh, these are fundamentally the same thing, but written a different way. If there's any ever potential concern, though, it is possible to, supplement J, same country, like a company, and clean it up. Yeah.
Right. If the company is not doing any of these technologies that in the labor certifications, and they have now moved on to a more advanced or the next generation technologies within the same scope of, let's say, database management or something of that nature, that's kind of the same thing, but it's a different technology. I think it's the same job. You file it. Now you're worried about that the skills and all these details are not really matching anymore. A great way to clean it up is by filing a supplement J after the adjustment. We're saying, hey, listen, it's the same job. We're just updating the technologies. Yeah. And that works.
Yeah.
But if the job, let's be very clear, if the job is let's say a director of the division, and the prior labor certification was an entry level, these are not compatible.
Ultimately, that's the sort of thing where we have a hard conversation with people and say, well, guys, you have to sign these forms in good faith saying you're willing to take this job. This is the job you want to offer him, and this is the job he wants to take. And if he's your director of technology now, I think you will have a hard time. Intent is in your heart, but it's also in the other records out there. I think you'd have a hard time convincing anybody that your director of technology is undoing their 10 years of climbing the corporate ladder to take this entry-level job.
Right. So it is 100% doable, reclaiming the old green card. You don't have to give up the current green card with your current employer. It can give you a great advantage in terms of allowing you to give yourself a second option. There is some intricacies and some highly technical things dealing with the
devil is in the details.
Interfiling, Child Status Protection Act, Supplement J, and whether or not it's an appropriate path for you that probably your attorney can discuss and advise you. And what about if the green card is issued now by this employer A? So what's your obligation?
Well, if you file with a company, you file an adjustment of status and a supplement J based upon an offer from that company. You're saying to the government, I intend to join that company when this green card's approved. And you know what you do? You join that company when the green card's approved. And then there's the question: can I go back to company B? Well, and the answer is it's that question of intent. Again, it's green card's approved. You know you're supposed to join company A. Company B, if they make a magical, compelling offer, that's a total
after the
green card's issued, a total change in circumstances. But you can't go into it, take a green card through one means, knowing that you're not intending to take it.
No intention of staying there.
Yeah.
But if things happen after the green card is approved, then that's fair.
Yeah. I mean, there are factors at play that can cause you to change your decision.
This is really an interesting topic about that. The dynamics of that.
There are people out there who say you can dump your dump your green card employer on day one, as soon as you get your green card? And the answer to that is you can, but it comes back to me for intent.
There's more to the answer than you can. You could, not you can, if the change in heart happened after the green card was issued, not before.
Yeah, 20 days before the green card comes in, I'm going to get this green card soon. I'm going to dump information technology.
Illegal.
Go start elect. Yeah, exactly.
That's improper.
Yeah.
It happens 24 hours after. It's proper.
Yeah.
If the offer and the opportunity and the plan and the circumstances occur after the green card, it's proper.
Are they questioning this right now? Are our phones ringing off the hook about no? However, it can come up.
The government is funny in picking on things sometime and switching gears and doing a 180-degree turnaround and start zooming on certain things.
Issues go dormant, and then the government. We think they all have a meeting or something, and they say, "Hey, what about blah? What about blah? We want to get people on blah again." And you get an RFE about blah when you file your naturalization application, and they'll say, "Hey, we noticed you got your green card, or what have you been doing since then?" It's incredibly likely to come out, but it's no. But I wouldn't, it wouldn't surprise me.
Yes. So that's our short presentation about reviving the old green card. Hopefully, it was helpful. And when we come back, we are going to answer your questions.
Yeah, send us questions. I like those. Well, Sam,
all right.
We're back, and it is time for questions.
So we're going to be taking questions now that you've posted on social media, and we're going to be answering them one at a time. First come, first serve, and hopefully we will have time to answer all your questions today. Anoop Patel.
Yeah, Anoop has a question which is it hits the very heart of last week's presentation, Anoop. It's, what does it mean when they say fingerprints applied? Do they go with a background check again or used from before? So I think Anoop's referring to getting one of these notices that says, hey, we reused your biometrics. So USCIS, for lots of types of cases, they will bring you in, get your fingerprints, do the biometrics thing, and occasionally they are able to reuse those from a prior case. And that's what it means. That's essentially it in my book. Right. Does it mean?
Do they go with the background check again? So they're using the prior data that they already accumulated on you.
Yeah. Yeah, I don't read that to associate anyway with a background check. Yeah.
All right.
So from Sarabi,
prior to 2016, have an EB2 I-140, never filed adjustment status. Is there any harm if I file a second I-140 under EB3? No, there's no harm whatsoever to file another I-140 under EB3 for that case. And if your 2016 is not current
hasn't made it current yet. It's never made it current before. That's why you haven't filed.
If you're born in India, obviously.
Yeah, if you're born in India. Yeah. But that other I-140 can be with your same employer. If you were filed approved in EB2 and they're willing to do another one in EB3 category, it can be with somebody else.
It could be a prior labor certification.
You can be very popular and have I-140s through tons of companies.
Yes. Yeah. If they're willing to do it for you.
Yeah.
Now, I should mention that the I-140 attorney fees can be paid by the employer or the employee.
Yeah.
That's legal. Not the labor certification or the adjustment status can be paid by the employer or the employee, typically paid by the employee, I'm sorry. It is not appropriate to have a financial deal with the prior employer on filing your I-140. So no discounts, no favors, no lower salaries. That's improper. All right, so we got Madhu. Go ahead, Brian.
So I refiled my EB2 on March 30th, 2022, as downgraded to EB3 in 2020 and biometrics complete, and also received EADAP. I received a notice from USCIS stating they can reuse biometrics, which doesn't reflect on the case. So I'm going to see if there's any follow-up here from Madhu, and I don't see anybody. So basically, you've seen that they've reused biometrics. It sounds like you got a notice in the mail, and you don't see anything about that on the online status of the case. My answer is, that doesn't surprise me. I wouldn't trust, I never trust the status of... the
online status?
Yeah, the online status too much.
What you receive from USCIS, that's a legal, defensible notice from the government, that's what you rely on. The online is just supportive information that's accurate at about 90% maybe.
Yeah. I mean, I find it's the later I get into a case, the less likely it is to be accurate. Yeah. I mean, getting receipt notices at the door, biometrics notices, I'll usually trust those are accurate. But RFE responses, I mean, those things aren't. You can't rely upon that. Yeah. So.
Asking for a friend from Surabi, Burma. Transferred on L1 and India operations would be closing. Can you continue on L1 and can you file for green card EB1? That's a great question. Well, that's a fantastic question. So if the India operation is closing, that terminates what we call qualifying relationship.
I have an asterisk on that one, Sam.
Go ahead.
There's a policy. You have to analyze it carefully. There's a policy out there that can be read that if the company still has some other foreign operations going somewhere else they could send your friend back to, you may be able to consider the L1A.
Oh, that's a fantastic point. So let's assume the company has a Singapore operation. This gentleman came from India to the US on an L1A. The same company is closing the India operation, but they have a Singapore operation. And they are qualifyingly related, and that's a legal term, meaning that they are connected enough to meet the L1A requirement. Then they're fine. But if there is not a third country in which that company exists in that third country, then the qualifying relationship is terminated, and both the L1A and the green card are dead.
Yeah.
So that's a red flag for your friend on his L1A status in the U.S.
For sure.
Yeah, that's an important question. He needs to consult, Surabi, he needs to consult with an attorney quickly on his L1A and the termination of the foreign operation impact on that.
Obviously, there might be means by which to change another status in the United States if you're happy here and.
If he had a prior H-1B, he can jump on H-1B. Or whatever.
Something I've helped people with before. I can think of a fellow once who he called me an absolute panic. He was here. Actually, his employer was so close to getting a green card in the EB1 category. And basically they said, we're shutting down our entire division of the business. And he had no other, can't be on L1 with another company. And ultimately we found out that he had a H-1B, and he found a company that was willing to sponsor him for H-1B, and they're going to sponsor him for a green card again. He might be delayed in getting that green card, he'll be changing categories, but ultimately, a guy was very, very thankful. I can go back to H-1B. Yeah, man, H-1B. You have an approved I-140 and H-1B. You can get on H-1B.
Boom. Yeah. So that needs to be looked into for your friend. Swiss seller. Can I apply for Canada electronic travel authorization as soon as I get a green card, or should I give a couple of weeks and then apply for ETA? So we are not Canadian immigration.
What are you talking about, Sam? I'm Canadian. I'm just kidding. I'm not Canadian. We don't do that well.
But I can answer the U.S. side of the question. Now, can you apply? That's a Canadian legal question. Does it impact your green card? That's the second part of the question. Maybe we can talk about that. An intent to apply for a foreign I don't know what the heck is a Canadian electronic travel authorization. Probably some kind of a travel document.
Well, yeah, it sounds like a temporary. Well, so I mean, really, Sam,
you're not applying for immigration to the U.S. To another country.
Well, it sounds like that's what you're dancing around. Are you basically doing anything to indicate that you're abandoning your residence in the United States?
I don't know what the heck this document is.
So
I do not know the answer to that question.
We're talking in general terms. Once you become a permanent resident, it is possible to lose that permanent resident by abandoning your intent to live in the United States. Right now, if that ETA again fully, we don't really touch upon Canadian immigration. We're a bunch of Americans. But if that ETA is about, if you're planning to go reside in Canada, that's going to be the place where you reside. It can definitely start raising questions as to whether or not you're still a U.S. green card holder. And next time you come back to the United States, if the U.S. government's aware, you've rented a place, you have a job in Canada, they can legitimately question your permanent residence in the United States. Yeah.
Right, but it doesn't look like that's the thing it is.
Yeah.
But be that as it may, sorry to disappoint, we don't have Canadian immigration law knowledge.
Yeah.
All right, cigar.
Let's see what cigar says. So, are EB2 straight refile I-45 cases being transferred from NBC to SRC as the applicant also had filed an EB3 downgrade in October 2020, and the EB3 I-140 is pending at SRC. Is this a current trend? So basically, are they sending the new case to the same place where the old one was? And so ultimately, what USCIS does can change, at the drop of a hat, wherever they feel is better for processing cases. But I guess the fundamental question for me, and we think about around here, is that filing that second case, getting people's green cards, is the other case going to slow down? The old case going to slow down the new case? And we are not seeing that. I mean, we are seeing anecdotally some of these second filings that are getting approved faster. So I guess that old EB3 I-140 is not going to, it shouldn't hurt your new one.
No.
Yeah.
And we have no knowledge of cases being transferred from NBC to SRC.
Yeah.
We haven't seen that.
Yeah. Ultimately, the trend is cases going to the
but
NBC.
Are they going to do it next week? Now that we said we don't know, or we haven't seen it? Possible. They're crazy. They come out with very illogical decisions sometime, but we haven't seen it, and it's not logical that they should do that.
Yeah. So kind of a relevant question that sort of segues off that. From RRH, I-45 case was transferred from SRC to NBC. Notice does not mention any particular field office, just NBC. Will the case be transferred again to a field office or processed at NBC? Any idea of NBC processing times? So, RRH, if you go to the USCIS website and you try to look up I-45 processing times for the NBC, you won't find any because, they just don't publish them. And everything we've heard indicates that, going to the NBC means it's going to a local field office. Just not necessarily your local field office, because they seem to be sending them to wherever they can to get the cases approved most expeditiously.
And last week, we have given you detailed field office by field office data on processing time and how efficient they are, and we've identified places like Houston, Texas, and Dallas, Texas, local offices that were horrifyingly behind. That's not the service center. And other offices like, if I remember correctly, DC, Washington, DC was terrible, but Los Angeles was really good.
Good news. I did post that spreadsheet online. If you look in the the YouTube about info for the last week's presentation, you'll find a copy of that spreadsheet for anybody who's curious to look at it.
At the request of Sweet Seller, he wanted to see it, so you made it available.
Yes, sir.
Which is great.
Now, I have heard anecdotally of people either calling USCIS on the phone or asking the EMA page at USCIS, where's my case at? And I have heard of people getting responses from that. And I guess I would say, we've also heard of people getting conflicting responses from that. Those things should be taken with a grain of salt. But I would generally trust the phone folks a little bit more than the EMA folks. But if you give them a call, they might be able to give you more specific information as to where specifically your case is. And your answer might be, and once you have that information, you can look up based upon the local field office. Yeah. Oops, scrolling too fast. There we are.
Ganesh.
So your June visa bulletin predictions, mainly EB2. It's got to be final action date, final action FD.
So we talked about that last week, and we felt that the movement of the final action date was to encourage interfiling.
Yeah, to encourage, getting all those cases out of EB3 into EB2. Yeah,
so we think there might be a movement for that purpose, because I don't think there is bandwidth to take more cases based on our analysis.
Yeah, when we looked at it last week. I mean, this was at the end of Q1 of the fiscal year. The records from USCIS indicated they had enough cases in their hands to eat up all those 290,000 visas, which points to us that the EB2 final action date movement has got to be slowing down.
but not necessarily they have it in the right spot.
Yeah. So
They don't have it, we suspect they don't have it because they're not going to move, there's not going to be an overflow from EB2 to EB3. For whatever reason, it's staying at EB2, and they're asking people to interfile back to EB2. So the way to do that is to move the final action date of EB2 forward.
to allow people to move into the EB2 category.
To allow
You
people
have to be final action current to move to interfile.
Yeah, and they're not going to go beyond the 2015 date.
Yeah, so the furthest EB3 made it forward was January 1st, 2015, as I recall, and thereby we don't think the EB2 date's going
Would ever cross that.
well, not during not during this fiscal year.
Yes.
But October is when new visas become available. We don't think it's going to be a big dump like it was the last 2 years, but you should still, we would hope for a little bit of more movement in October.
In summary, in case we confuse you, yes, we believe there's going to be a forward movement in EB2 final action date for next month.
Yeah, up to about January.
Few months, maybe
I
three.
think we're in December. I'll have to look at my visa bulletin, but
3 months movement. Would that be reasonable?
I think it might be less than that, Sam. As I grab my visa bulletin here, because it's really about where the final action date is right now. My mistake. So final action dates for employment EB2 is in 1st of September 2013. I think it still has some bandwidth to move.
3 months. I'm thinking because we looked at the last 4 or 5 months and it was moving average between 2 to 5 months is the slow. So it's going to be in that range.
2 to 3 months is a fair guess. Yeah. So here we are, Vijay Singh. My underlying EB3 I-140 has April 23rd, my underlying EB3 I-140 has April 2013 priority date, or my EB2 I-140 priority date is May 2014, both of the same company. Can I interfile it under EB2 and request them to use the April 2013 priority date? This is an interesting one, Sam. What's your take on that one?
Well, first of all, I'm assuming you have 2 different labor certifications. Because if you have one labor certification for both, something wrong. So that's number one. So we're going to go with the assumption there are 2 labor certifications. You can ask them to interfile and use whatever priority date you believe you should use. Yes, good luck getting them to figure it out.
So let me state a different way. So the general rule of thumb is your earliest priority date, assuming there's no fraud or misrepresentation or serious problem with the original I-140, is that you can always take that priority date forward. But you're in a curious situation where they didn't do that for you, and it's one of those hair-pulling, anxiety-induced nightmares getting USCIS to fix that, especially after a case that's been approved for a long time.
Right, but if they give you the May 2014 priority date for the EB2, you just need to keep an eye on April 2013 for that case, and then go full press attack on the USCIS to get them to acknowledge that priority date for
shoot up a couple of letters and just
Oh yeah, raise all kind of hell. Yeah. I mean, congressman, ombudsman, phone calls.
I mean, that's a year of difference.
You can go full blast at that time, but make sure that you hit that priority date first, because you can try it now. They're not going to prioritize it because your priority date may not be current for April 2013, is it? Can you look since you have that?
Being April 2013 priority date. So
EB2.
No, EB2 is EB3. EB2 is current. EB2 is in September of 2013, so it would be current in the
now. So you can now start putting raise all kind of hell with them.
Yeah, I mean.
Vijay, you need to put some pressure. Yeah, you need to kind of get that going here.
I mean, in your interfiling request, you can lay this out, but the only problem is you have to convince somebody to understand.
But that's a big deal.
Yeah, that's a big deal. It's a difference. If a difference between a year.
Heck yeah. If you're current now under 2013, you need to have that EB2 now in adjudication to get your green card issued.
Yeah.
And if you don't do anything about it now, nobody's going to do it for you.
Yeah.
So get started. Come out with your list. Get an attorney involved, and start turning the heat on.
Yeah, I imagine that interfiling request is going to involve some very, very bright highlighted text saying, please, please, please accept this. Look, they made an error last time. You can help me fix it, and hopefully
you don't even need to. The EB2 I-140 priority is May 2014. You don't even need to interfile. You can ask them to consider the 2013.
Yeah,
but without interfiling. Now.
Yeah, this is very. You're right. Well, he has to interfile because he filed his adjustment in EB. I presume this person filed an adjustment based upon the EB3.
You need an attorney to look at this for you quickly and get things rolling for you, my friend. All right, you got us excited, VJ, with that one.
I have another good exciting one, Sam. This is Sweet
Whoa.
Seller.
Whoa! Wow. Well, we have one of those. I'm not sure. This one?
Sam pushed a button, and we can't hear what noise it's making. So I apologize if it just made a terrible shrieking noise.
I think this is the clapping noise, but if it's not, I apologize.
What was the boo noise, Sam?
Not on here.
Okay.
I hope not.
I know, right? Anywho, so congratulations, obviously. So
Continued. Listen more.
Continued. I mean, I'm sure. I know it was a long wait.
That's amazing. That's wonderful.
And he has a suggestion for us. So can you start the show a few hours late or move to Thursday if possible? Helps West Coast viewers late in the day, late in the week, avoid overlaps at work. I want you to enjoy your Fridays.
We will certainly take it under advisement. Move a show to Thursday, a few hours late, or move the show to Thursday. Well, maybe we should do a vote on that.
Yeah.
So I think we can do a vote on YouTube and see if we can get that.
Yeah, we have the means to send out a poll to people, and I mean, obviously everything's available.
I don't mind moving it later. Yeah, we can consider.
The worst case scenario is you just might get Brian from his home office and Sam from his.
No, we need to meet here.
We need to meet here. All right.
Yeah, to make it work. But moving on here to answer other people's questions.
Yeah, that's just good.
Yeah, and
good.
we kind of paused a little bit, so we're gonna go another 5 minutes today because I don't want to get people upset that we didn't answer their questions.
So Pakal Prasad. So EB3 was transferred to NBC. I'm from Houston. Would my field office be Houston, or can it be one of the lesser loaded field offices? USCIS discretion controls this. So to answer that last question, yes.
It could be a lesser loaded office, but that's going to be the luck of the draw.
Yeah, I mean, I think, well, if you for whatever reason are in there, if one they want to interview you, if they want to interview you,
it's going to be in the local.
It's going to be in Houston. Yeah.
Yeah. So Houston is not doing good, by the way, based on the numbers we shared last week.
And ultimately, everything they sent out, they said, we're moving cases to the NBC, and by NBC we mean local field offices to move them faster. And again, check out that spreadsheet that we put on the last presentation. That's sort of indicates how the local field offices were doing at the end of Q1. However, in Q2, the data will be here in like a month or two, and it will be very interesting to see how many cases those offices are reflecting in the employment-based categories, because it'll be reflecting this move.
I want to add a caveat because I left the meeting last week feeling a little bit guilty, and I want to clear my conscience.
Okay.
It is likely, although not so likely, but it is likely that that these transfers may have occurred at the very end of the quarter.
Yeah,
and therefore, these numbers and the performances are skewed because they didn't have time to process them.
Yeah.
It's possible, but these numbers is what USCI's data shows, based on what's been processed. And I doubt that's true. But potential that maybe we piled on certain offices and it's not their fault, but I feel like our assessment is more accurate than not accurate.
Yeah, I mean, well, yeah. I mean, we ran the numbers, and some of them just don't look very good.
Yes.
So can I raise a service request? My case is out of normal processing time. So as I recall, the general service date inquiries for employment-based adjustment of status was in September of 2020. Maybe they moved it up. So, however, I haven't received the I-45J receipt, EB2, EB3 to EB2, and my priority date is not current in EB3, but in EB2. So presuming, you have... Have you put in your interfiling request to EB2? Is my question.
Well, if it's current in EB2,
it looks like he mentioned the I-45 receipt EB3 to EB2, so it looks he did put in an interfiling request.
Yeah, but current in EB2, so his situation is current, and he needs to know what the heck is going on.
Yeah.
That's outside processing time. Yes, you got to do a service request. You got to start putting some pressure.
Yeah.
Definitely, you got to start making some noise. And the squeaky wheel gets
Gets the grease. Now, I've been, there's a lot of squeaky wheels out there, and USCIS has been known to say, wheel, shut up, I don't care. You and all your friends are squeaking. However, you're right. You know, squeaky wheels have occasionally,
gets a little bit more attention.
Yeah.
But I would definitely start putting some pressure and start saying, what the heck is going on? Where is my case? But yeah.
Yeah. So, can I revive an I-140 in the EB1 C category?
Yeah, employment-based. But EB1C is that is going to be outstanding researchers.
No, I'm pretty sure that's managers and executives.
A is extraordinary ability. B, manager exhibit EB1C. L from the L1A. You can you if it's approved.
My problem is that that one of that might be.
The answer is yes. Theoretically, yes. Now we need to know a lot more information to just say definitively yes.
Yeah.
It can be done.
Yeah. I mean, an I-140.
But see, the EB1. I'm sorry, Brian, to cut you off. But the EB1C reviving it is not as impactful. But you have the old priority date.
Ooh, that's well. You're always entitled to that priority date, though.
Yeah.
So
it's not as impactful because there's no labor certification behind it. You might, but the answer is yes, you can. But there could be other avenues that could be equally as effective. In your scenario.
I mean, an EB1 case is a big case, and they are complex, and that's something I would want to.
So in his scenario, I'm going to fill the gaps. Yeah. EB1C, filed, approved, but adjustment of status never been filed. Okay, now, the question is he can go back and join that employer and file an I-45.
I ponder about that, 3 years of the last, one of the last 3 years requirements for an EB1. I'd want to really mull over that for a little bit before I commit to this.
So you're concerned that the foundation of that employment may be because he is no longer working for this employer during the last 3 years. You present a very interesting topic and a concept that needs to be looked at carefully.
Yeah, I mean, it's if you're from India, I mean, that could be huge for you because who doesn't want to be in the EB1 category? We know what the wait times are in EB1 versus EB2 and EB3.
Yeah, there are more details, and Brian, you raised an excellent point.
Yeah. So, any pattern for transferring I-45 from Texas to NBC, is it based upon priority date or receive date? So.
Most likely priority date, and most likely priority date.
So AILA had the American Immigration Lawyers Association, regularly liaises with USCIS, and they had a talk with them, and I think this was in early April or maybe late March, and they said, hey, USCIS told AILA that we are transferring cases from Texas and Nebraska to the NBC, i.e. the local field offices, and basically what they were transferring were the cases that were sitting and not moving. So cases that were sitting with an officer right now under review, those are going to stay.
That are current.
Yeah, the ones they're actively working on, which means current ones, are going to be staying with where they are because there's somebody already working on them. The ones they're not getting to are going to be going to these NBC, the field offices for quicker action. How is it done? I would hope it's based upon priority date.
Well, it has to be because they will not even bring him off the shelf if the priority date is not current.
So I guess you're bigger. Yes. So ones with current priority dates are the ones they should be moving around because they wouldn't move cases without current priority dates to elsewhere because there's no point.
Within the priority date, are they transferring them based on receive date? So that's the question. When you remember your Excel sorting, you can do multi-layer. So within the priority date, I don't think they're that sophisticated. I think they're just grabbing boxes.
Yeah. I mean,
that's my personal opinion, but it's not substantiated. But that's
here. I'll substantiate it a little bit for you anecdotally. I've talked to plenty of people who said, my friend who lives in blah, and he's got a priority date, a year newer than me in the EB3 category. He got his green card. I haven't gotten mine yet. What's up? And so they aren't. Nobody. The next guy. I mean, person's working on one case for one priority date. The rest of the office isn't waiting for that guy's case to be approved to work on the next one.
Yes. All right, so moving on to the next one here, and it's we're taking two more.
Yeah, let's do about two more.
Stick them in order, Brian. Don't roll
I'm just
it
seeing
because
how
somebody's
many-
waiting
Wait,
anxiously. and we skip
here we
something.
are. I didn't mean to skip one. I didn't mean to skip one. Okay.
Yeah, thank you.
So.
Smart apps. All right, I like the name Smart Apps.
It means he or she is associated with smart apps.
Yeah.
So EB2 AOS pending. If I become a citizen of Canada before the I-45 approved, what would happen? Anything I need to know as my Canadian citizenship application is also in progress. Whew.
EB2 adjustment is pending, and I became a citizen of Canada before the I-45 is approved. Hold on a second. So what would happen? Anything I need to know as I'm Canadian citizen applicant is also in progress. Well, is it approved or is it in progress? Anything I need to know as my Canadian citizenship application is also in progress. I become a citizen before that.
If I become, so basically I have a pending adjustment, I interpret this, I have a pending adjustment of status in the United States applying for permanent residence, but I also have a pending Canadian citizenship application.
So you have a multiple, and you can probably take the position that whichever is approved first, I will approve, and then once you become a permanent resident of one country, it creates a complex legal question. However, it's in my experience, I haven't seen USCIS dig into this issue because it happens all the time. Everybody who's applying for a US green card, not everybody, capable, is also applying for Canadian green card and citizenship because the length of time it's taking to process green cards in this country is pathetic. And therefore, people are going with Plan B because they don't know when the heck the green card in the US will be approved. Therefore, it's legitimate to do that. It is my experience, USCIS does not raise this issue whatsoever.
Yeah, I mean, it's what you do that really matters in the eyes of the U.S. government. Are you intending to live in the United States as a permanent resident? USCIS can approve your green card case. I can't speak to Canada, but as long as USCIS believes you're intending to be here as a permanent resident.
Point.
Yeah.
Excellent point. All right, taking one more, Brian.
Okay, make sure I do it in order.
In order.
In order. Oh, the area where I'm viewing this is so small.
No, you went down.
Did I?
Yeah, the other direction.
Okay. Okay, here we are. Okay, I went way too far. There we are. So any prediction for EB2, EB3 for October 2023 for prior date of October 2015? Whew, that's a long time out, Sam. That's a year and a half.
Not possible, Raj. I don't have the ability.
I don't have the ability. So I'll talk about a sooner October 2022. New visas are available every October, and thereby you expect a little bit of movement, greater space of movement in the Octobers of the year.
With that, we conclude today. We conclude today's presentation. Thank you guys for listening to us, and have a wonderful the rest of this evening.